Welcome from the heart of Munich to the Data Protection Café. Today's topic is data protection and the personnel file. The personnel file naturally contains numerous personal data about the employee. It is important here to comply with data protection regulations, whether in electronic or paper form. More about which regulations these are in today's video. For personnel files, whether in electronic or paper form, the requirements of the GDPR in conjunction with the special provisions of the Federal Data Protection Act apply. The relevant standards are also displayed here again. This means that we must adhere to the general data protection standards when managing the personnel file. First of all, the employer must maintain the personnel file in such a way that it provides a complete picture of the employee and the employment relationship. The affected employee has the right to access information and also has the right to have incorrect information corrected and to have the corresponding data removed if the reason for storage no longer exists. The personnel files should provide the most complete and comprehensive picture of the employment relationship possible. In particular, the personnel file should include information about the person, their performance, and their activities. The employee has the right to ensure that the information recorded there is factually correct. Every employee is entitled to exercise their right of access, meaning they can view the personnel file. They can specifically have incorrect information corrected. If service providers are used to manage the personnel file, a corresponding data protection agreement, i.e., a data processing agreement, must be concluded with this service provider. Link to an in-depth video on this topic below in the description. In practice, two topics are always in focus when it comes to the personnel file. One aspect is access management, the authorization concept, who can access which data and how. The other major topic is the deletion concept, which addresses which data from the personnel file must be deleted after certain periods. Let's take a brief look at the authorization concept. There is also a detailed video linked below. The principle here is that access to the personnel file is only permitted to the extent necessary. This means we need a role-based authorization concept within the company that precisely regulates who in the HR department can access which data sets, where corresponding operational necessities exist. And it should, of course, be designed in such a way that as little access as possible is granted. This means being more cautious when granting access rights in case of doubt. In particular, sick notes should also be considered separately in the authorization concept, so that only the necessary individuals within the company can access the sick notes. Comparable requirements apply to the deletion concept. Here too, it is important to specify as precisely as possible which data categories are to be retained for which period. If there are no longer any legal or contractual retention obligations, the data must be deleted accordingly. We also have an in-depth video here that separately highlights the deletion periods, linked below. If you still maintain personnel files in printed form, it is also important that they are stored separately. Typically, this means a lockable cabinet in the personnel area. And when destroying paper documents, please ensure that this is also done in compliance with data protection regulations. So do not dispose of it in the regular paper waste, but in the data bin or shredder. To quote Marie von Ebner-Eschenbach, "It is not the work we do that tires us, but the work we leave undone." And with that, there are two main topics to consider when managing the personnel file. On the one hand, a sophisticated authorization concept ensures that only those within the company who have a legitimate reason can access the personnel data. On the other hand, a differentiated deletion concept to ensure deletion within the personnel file system after the legal basis has ceased to exist. And if service providers are used to manage the personnel file system, these service providers must be bound by data protection regulations through data processing agreements. What else has happened regarding the topic of major German providers blocking the shadow library Sci-Hub? More on this in the link in the description. Enjoy reading.